In any event, we got to work then in mostly in March of 2004, drafting a petition for writ of habeas corpus to file in federal court here in Seattle. And you know, the case came out to Seattle in the first place through David, but I'm not sure if we explained why they wanted a Washington State venue. What was going on was a circuit split on a jurisdictional question. The D.C. Circuit and the Fourth Circuit back in Virginia and the East Coast had already held that federal courts do not have jurisdiction to consider habeas petitions for Guantanamo detainees. For these enemy aliens offshore, there is no jurisdiction for them to file a petition for writ of habeas corpus to challenge the authority of the President of the United States to indefinitely detain them. In a sense, what the D.C. Circuit and the Fourth Circuit were doing was, they were sort of ratifying the whole use of Guantanamo to begin with. The idea of Guantanamo was a legal black hole. Get these guys in a place beyond the reach of law, so that the executive branch is unaccountable for conduct taking place there. And that's why they were put in Guantanamo, because there was an argument, and a good argument, that the jurisdiction of federal courts did not extend on habeas to those individuals. The Ninth Circuit, however, held otherwise. In a case called Garabi, that had worked its way up to the Ninth Circuit prior to the filing of our petition in early 2004, the Ninth Circuit said federal courts do have jurisdiction to entertain petitions for writ of habeas corpus. The great writ runs wherever the United States government exercises effective control and jurisdiction. And one of the things that we learned in the course of this case is the history of the writ of habeas corpus, and its role, its central role in the preservation of liberty, from the very beginnings of the Anglo-American legal tradition. And we had amicus briefs from, legal historians, from parliamentarians in Great Britain and elsewhere that detailed for us and for the court the scope of the writ of habeas corpus and its centrality in guaranteeing this most basic legal right, the right to be free from arbitrary detention and to challenge that detention, to challenge your prison, your jailer, to justify your detention.